Hello, and welcome to this overview of FTA's Notice of Proposed Rulemaking on Rail Transit Roadway Worker Protection. My name is Jeremy Furrer, and I'm the Division Chief for Safety Policy and Promotion. I will also be joined by Mia Veltri, Senior Policy Analyst in the Office of System Safety. During this session, we will provide an overview of the proposed rulemaking on Rail Transit Roadway Worker Protection. The Notice of Proposed Rulemaking, or NPRM, was published March 25th, 2024 for notice and comment. The notice and comment period is open for 60 days and will close May 24th, 2024. During this session, we will provide an overview of the proposed rulemaking on rail transit roadway worker protection. This will include background information, an overview of roadway worker protection, an outline of the NPRM, our anticipated timeline, and information on how to comment. First, I want to give you a bit of background as to why FTA has proposed this rule. Unfortunately, unsafe practices and conditions still exist in the transit industry that place rail transit workers at risk of being killed or seriously injured while performing work. In the 15-year period between January 1st, 2008 and October 31st, 2022, 22 workers have been killed and 120 workers seriously injured in safety events on the roadway. This is approximately 1.5 workers killed per year and just over 8 workers seriously injured per year. This trend has continued over the past year, and in November of 2023, we saw major safety events occur involving workers from the Southeastern Pennsylvania Transportation Authority, the Chicago Transit Authority, and New York City Transit. The purpose of this proposed rule is to prevent tragedies like these by establishing minimum safety standards for transit workers who access the roadway performing work. This proposed rule would impact transit workers, rail transit agencies, meaning any entity that provides services on a rail fixed guideway public transportation system, with the exception of commuter rail, which falls under the jurisdiction of the Federal Railroad Administration's safety regulations, and state safety oversight agencies responsible for overseeing those rail systems. This proposed rule was drafted with the intent to provide baseline protections for workers across rail transit agencies. The proposed rule would also implement standards that are not one size fits all. While some requirements would, of course, apply across the board, there is flexibility that accounts for agencies of all sizes. The proposed rule would also provide a clear role for state safety oversight agencies. And last, the proposed rule would require rail transit agencies to use their safety management systems to determine additional appropriate mitigations where needed. This proposed rule is not meant to detract in any way from agencies' existing safety management systems and procedures, but rather to ensure baseline protections across the industry that can be expanded upon. Now, I'm going to hand it over to Mia to walk us through the provisions of the proposed rule.
Thank you, Jeremy. The structure of the proposed rule includes the following 5 subparts. Subpart A, General. Subpart B, RWP Program and Manual. Subpart C, Responsibilities. Subpart D, Required RWP Program Elements. And Subpart E, Record Keeping. This proposed regulation would apply to RTAs that receive federal financial assistance under 49 U.S.C. Chapter 53, all SSOAs that oversee the safety of rail-fixed guideway public transportation systems, and transit workers who access the roadway while performing work. As mentioned, this proposed rule would not apply to rail systems that are subject to the safety oversight of the Federal Railroad Administration, which includes commuter rail systems. This is the first FTA and PRM to propose mandatory minimum standards. Rail transit agencies would be expected to integrate these mandatory minimum standards into their agency's safety management systems. Again, these requirements are meant to function as a baseline. RTAs and SSOAs could establish additional requirements for their RWP as appropriate, as long as there's no conflict with the federal standard. This subpart also proposes definitions for terms used in this part to establish a standard RWP vocabulary. Under this proposed rule, RTAs would be required to have an RWP program. The program would require an RWP manual, risk-based redundant protections, which means at least one additional protection beyond simply relying on a worker to see approaching rail transit vehicles or equipment, RWP training and qualification program, and RWP compliance monitoring program. Under Subpart B of the proposed regulation, RTAs would be required to create, maintain, and distribute a dedicated RWP manual that includes terminology the agency uses for the RWP program, clearly defined responsibilities for workers, required training, qualification, and supervision for activities on or near the roadway, and processes and procedures for accessing the track zone. Track zone meaning any area where a person could be struck by equipment on the track. RTAs would be required to review and update this manual at least every 2 years. Also included in this requirement, RTAs must also create and maintain a track access guide. This document would describe the track system, including track areas with close or no clearance, curves with blind spots or restricted sight lines, areas with loud noise, and potential environmental conditions that require additional consideration in establishing on-track safety. Subpart C of the proposed rule enumerates responsibilities for transit workers. Transit workers would be expected to follow the requirements of their agency's RWP program. In addition, they should never foul the track unless it's required for work, they've received permission, and all the proper protections specified in the RWP manual have taken place. Transit workers would need to understand the protections and attest to that in writing before they access the roadway or track zone. Finally, transit workers would be mandated to report unsafe acts and conditions and near misses using processes defined by the RTA. This subsection also reaffirms the right of a transit worker to refuse to foul the track under a good faith safety challenge, which I will discuss again shortly. Proposed responsibilities for rail transit agencies are enumerated in Subpart C and include establishing procedures to provide ample time and determine sight distance, prohibiting using individual train detection as the only form of worker protection, which means agencies can't rely on workers to just see oncoming vehicles, providing job safety briefings to all workers who must enter the track zone to perform work, providing the right to good faith safety challenges, requiring workers to report unsafe acts and conditions and near misses, and ensuring that workers understand, are qualified in, and comply with the agency's RWP program. Under the proposed rule, RTAs would also be required to establish required equipment and protections, such as personal protective equipment for accessing the roadway or track zone, required credentials, such as a badge or wristband or RWP card, required protections for emergency response personnel, and required protections for multiple work groups within a common location. Under the proposed rule, SSOA responsibilities would include reviewing and approving the RWP manual and any subsequent updates for each RTA within its jurisdiction. The proposed rule also requires the SSOA to complete initial approval of the RWP program elements within 90 calendar days after receiving the program. The SSOA would also need to submit all approvals to FTA within 30 days. This includes all approved RWP elements, including later updates. SSOAs would also be required to monitor the RWP programs for RTAs under their jurisdiction and conduct annual compliance audits and require corrective action if needed. Corrective action plans, if necessary, would need to be developed and executed consistent with requirements established in 49 CFR Part 674, the regulations on state safety oversight. This proposed section, roadway worker in charge, would require an RTA to designate a roadway worker in charge for each work group. This means a roadway worker who is qualified under this part to establish on-track safety. This individual is responsible for providing on-track safety for all members of the roadway work group. They would be required to provide a job safety briefing before any member of the group fouls a track, and if any of the on-track safety procedures change, or immediately following the occurrence of a violation of an on-track safety protection, the roadway worker in charge would be required to provide a follow-up briefing. Section 671.33 of the proposed rule covers job safety briefings in more detail and specifies specific topics a briefing would need to include. For example, designated places of safety. In FTA's review of prior safety events, we found that weak job safety briefings contributed to safety events, placing workers in situations where they may have not been aware of the hazards on the worksite or the requirements for protection. Insufficient training also left workers vulnerable to errors of judgment on the roadway. The roadway worker in charge is responsible for confirming that each worker understands the content of the safety briefing and that each worker acknowledges the briefing in writing. If there is any change in the scope of work or roadway work group after the initial job safety briefing, or if a violation of on-track safety is observed, a follow-up job safety briefing must be conducted. In this NPRM, lone worker means an individual roadway worker who is not afforded on-track safety by another worker. In the proposed rule, RTAs could authorize lone workers to perform limited duties that require fouling a track only under limited circumstances. For example, in certain locations only, certain protections must be in place, and the worker must meet certain training requirements. Each lone worker would be required to communicate with a supervisor or other designated worker to receive an on-track safety briefing prior to fouling the track. This briefing would need to include a discussion of the planned work activities and the procedures for on-track safety. Again, the lone worker would need to acknowledge and document the job safety briefing in writing. This section of the NPRM proposes that RTAs must provide roadway workers the right to challenge and refuse in good faith any RWP assignment they believe is unsafe or would violate the RTA's RWP program. RTAs would be required to document the procedures for this good faith safety challenge. The written procedure would need to include methods to ensure prompt and equitable resolution of any challenges and refusals made. The written procedure would need to require the roadway worker to provide a description of the safety concern regarding on-track safety and require that the roadway worker issuing a good faith safety challenge remain clear of the roadway or track zone until the issue is resolved. This process reflects common industry practice and empowers transit workers, who are often the most familiar with the particular needs and hazards related to their specific job task, to appropriately address unsafe situations. Redundant protection means that there is at least one additional protection beyond individual rail transit vehicle detection to ensure on-track safety for roadway workers. The NPRM proposes that the RTA use their safety risk management process to assess safety risk and establish redundant protections. Redundant protections may be procedural or physical. Under the proposed rule, the RTA would be required to review and update the safety risk assessment at least every 2 years. RTAs would be required to establish and layer redundant protections that are proportionate to the work being performed. FTA proposes to require, at a minimum, redundant protections for certain categories of work, including for lone workers or workers using or conducting visual inspections. The SSOA may also identify and require the RTA to implement alternate redundant protections if it's deemed appropriate. This section of the proposed rule would require RTAs to adopt an RWP training program with both initial and refresher training for roadway workers. This training would be required to include interactive training with the opportunity to ask the RWP trainer questions and raise and discuss RWP issues. The proposed rule also includes certain minimum requirements for the training program, such as hazard recognition and mitigation training, and specifies refresher training would need to occur at least every 2 years. Both the initial and refresher training would need to include a demonstration of the worker's ability. Additional examples of what the RWP training program must cover in this proposed rule include how to understand and use the RWP manual and track access guide, the good faith challenge process and how to report unsafe acts and conditions and near misses, and the functions and responsibilities of workers involved in on-track safety. This program would need to include specialized training and qualifications for transit workers with additional responsibilities, such as roadway workers in charge. And it would be the responsibility of the RTA to ensure that their RWP trainers are competent to provide effective training. This section proposes that RTAs develop a program to monitor their own compliance with the requirements in their RWP program. This monitoring program is consistent with safety assurance principles and is intended to ensure consistent and effective RWP program implementation. FTA proposes that this program must include inspections, observations, and audits. In addition, under the proposed rule, the RTA would need to provide monthly reports to the SSOA documenting their compliance with the RWP program, and the RTA would need to provide an annual briefing to the accountable executive and the board of directors or equivalent entity regarding the performance of the RWP program and any identified deficiencies requiring corrective action. The last subpart is record keeping. Under the proposed rule, RTAs would be required to maintain the documents that set forth the program for a minimum of 3 years. This includes documents related to implementation and the results of the program. RTAs would need to make these documents available upon request by the FTA or other federal entity or an SSOA having jurisdiction. I will now hand it back to Jeremy to go over our timeline and how to submit a comment.
Thank you, Mia. As we are recording this session, we are currently in the 60-day public comment and review period for this rulemaking. The notice and comment period will end on May 24th, 2024. FTA will then review and consider all public comments. The publication date of the final rule is not yet determined, as it will likely depend on the nature and number of comments we receive. We do ask that you submit any input you have by visiting the Federal Register. You can find the NPRM by entering the docket number you see here into the search function, or by scanning the QR code on the screen. For additional information on submitting public comments, you can view Tips for Submitting Effective Comments, an overview provided by regulations.gov. Again, you can visit this page by scanning the QR code. Your feedback is a critical part of the rulemaking process, and we will review and consider each comment as we develop a final rule. Thank you in advance for taking the time to provide your valuable input. Thank you for listening to this session. Please feel free to contact Mia Veltri via email or by phone with any questions you may have. Her contact information is on the screen. Thank you for watching this presentation. Stay safe.